God save the United States and this honorable court. Be seated, please. Case number 21-1191 et al. Constellium Rolled Products Ravenswood LLC petitioner versus National Labor Relations Board. Mr. Keneally for the petitioner, Mr. Heller for the respondent, Mr. Gilbert for the intervener.
Mr. Keneally, good morning. Please proceed.
Thank you, Your Honor. And may it please the court, Michael Keneally on behalf of Constellium, I'd like to reserve 3 minutes for rebuttal. For 20 years, this court and its members have told the NLRB that employees do not need special leeway to engage in sexually or racially offensive conduct to further their interests under federal labor law. But employers do need broad latitude to discipline such misconduct to fulfill their responsibilities under the Equal Employment Opportunity Law. The board looked like it had gotten the message in 2020 in General Motors. That case replaced the board's flawed existing framework with the familiar right line test. It recognized that sexually or racially offensive conduct is analytically distinct from protected concerted activity, even when it is performed for the sake of protected ends. The ends don't justify the means. Now an employer may lawfully combat offensive misconduct, it just can't retaliate against protected activity. Unfortunately, the board's ruling in this case is impossible to defend under that approach. And the clearest signal of this may be the two main defenses that board counsel and the union proposed in this court. First, a meritless appeal to the law of the case doctrine, and second, the same analytical mistake that General Motors condemns, namely collapsing the distinction between the abusive misconduct and the protected activity it seeks to further. The board's decision on remand commits two significant errors, either of which is sufficient to deny enforcement. First, the board completely ignored its own prior finding that Constellium broadly tolerated the protected activity here, the overtime protest, as well as the ALJ's related finding that Constellium lacked animus toward the protest. And second, the board fixated on supposed evidence of disparate treatment as its sole basis for animus, but it failed to scrutinize this evidence to ensure it actually suggests animus. And worse, this single-minded approach recreates the very conflict between labor law and EEO laws that the board...
Is animus really the only issue that's left beyond law of the case?
I think animus is the central issue, Your Honor. Mm-hmm. We do have an argument at right line step 2, but a lot of the evidence is the same for both prongs of the analysis. It's really a question of who bears the burden. Of course, the board bears the burden on animus at step 1, and that was the part of the right line analysis that the ALJ seized upon in his original ruling. So we think, I would suggest animus is probably the core issue for the court. And on animus, I think the first thing that the board did wrong was refuse to even analyze the board's own 2018 finding that the company had tolerated a wide range of activities in support of the protest. And
nothing was introduced that they tolerated anything like what happened here, where you got the actual offensive language written on the sign-up board, a video of him doing it. Nothing rose to that level or sank to that level, did it, of what they offered?
No, Your Honor. There was no comparable episode in the record. The only things that the board cited in its decision as comparable misconduct were verbal use of the phrase. We're not clear exactly on the timing for that, but there's some evidence that it occurred before Mr. Williams and some evidence that it occurred after Mr. Williams wrote the words. And then graffiti usage, but there's no indication that the company knew who was responsible for the graffiti. And the union's own representative, Mr. Beagle, testified to that at the hearing. So we do think that the only reasonable inference based on the employer taking no action for 6 months of overtime boycotting, when that caused significant operational issues for the company, which Mr. Harmison testified about, is that the company took action shortly after Mr. Williams wrote the phrase on the bulletin board in a centrally located location on employer property, which then prompted the specific individuals who had already filled out their own initials and signed up for overtime to complain that they felt offended. And in fact, one of them asked the company to intervene and said that he felt targeted. It's Mr. Lawson. So there's nothing comparable to that the employer could be accused of having failed to correct. And I think that's why the ALJ found this to be a pretty straightforward case for finding of no animus. The board was at a minimum required to grapple with that history, which is not disputed. The facts aren't disputed on that point. The only possible dispute is its significance. But I think that after the board said in 2018 that this history was not relevant under Atlantic Steel, the old framework, and then this court acknowledged the history and even said it might be significant under right line, but at that time, right line was not the operative test, so it wasn't significant then. But then when right line became the test on remand after General Motors, the board had a duty to grapple with this evidence, and we cite a number of cases from this court that say that when the board completely fails to consider an important aspect of the problem, basic admin law, that the decision lacks reasoned decision-making and is arbitrary and capricious, especially when the board also fails to explain the basis of its disagreement with the ALJ. So that would be our first submission before this court, is that the board failed to grapple with that extremely important evidence and the ALJ finding. On the disparate treatment point, we think is a second error, and in some ways, maybe even a more significant error, given its potential implications for future cases. The board made no effort to ensure that the comparable cases showed genuine pretext, that the employer was not really motivated by what Mr. Williams did, but was instead motivated.
Both of those issues really blend into one. I mean, the significance of disparate treatment is to show that, or attempt to show, that the board wouldn't have taken the action based on the wrongdoing alone, and therefore it must have had anti-union animus.
I think that's right, Your Honor, but I think in the General Motors type of case, and this type of case specifically, it's especially important to consider the evidence of disparate impact because under the hostile work environment laws, a plaintiff can prevail based on either severe or pervasive workplace mistreatment. And so courts look at that in hostile work environment cases in the aggregate. And so it's no excuse under the EEO laws that comparable misconduct has been ongoing. In fact, that just makes it worse. Under those laws, an employer has to be able to say enough is enough, whether because the conduct has gotten worse, as I think is the case here, or even if it just continues unabated. Eventually, the employer has to step in and put a stop to it. But if under the board's approach, if we're not going to consider whether the employer had any other indications of animus towards the protected activity, and we're not going to really evaluate whether the episodes of past misconduct that went uncorrected are comparable in a meaningful way, then the employer is really locked in to tolerating misconduct under the NLRA based on toleration of past episodes. And I think the union's brief is particularly transparent on this because it argues at 31 that it shouldn't be easy for employers to turn over a new leaf if they failed to correct misconduct in the past. But that's exactly backwards under the EEO law. And so I think that
we don't have to acknowledge kind of that approach, though, to affirm what the board did here, right? I mean, if you've dug yourself into a hole because you haven't really been enforcing, the company, been enforcing anti-harassment and anti-discrimination laws. And so it's going to look like disparate treatment if you all of a sudden start doing so, and coincidentally it's someone who is engaging in protected union activity when you finally make the decision to start doing so. Then, why should we have much sympathy for that? That doesn't mean that you can't tomorrow start enforcing those laws uniformly across the board. And And if you have a situation where someone is arguably engaging in protected activity while they're doing something that's harassing or discriminatory, you won't be the subject of a successful kind of pretext action. Why isn't that just the way that this can work out? And why isn't that reasonable?
Well, we certainly aren't arguing for, a categorical rule that disparate treatment evidence can never be a sign of pretext. Here, there's no evidence that Constellium failed to take comparable action after it disciplined Mr. Williams with respect to other individuals who had prompted an investigation, who had caused their coworkers to complain in a similar way, and whose identities were known to the decision makers here. But I think with this particular record, it's extremely hard to avoid falling into that catch-22 where the employer can't comply both with federal labor law and the EEO laws, given the history of tolerating the overtime protest that had gone on for 6 months. And that sort of temporal lack of any sort of temporal connection, temporal proximity between the start of the protest and...
I think I heard you arguing before that they really haven't violated federal labor law.
Yes.
If they're acting without that anti-union animus, they're simply disciplining for this egregious conduct, then there's no federal law violation, right?
Yes, that is our position. I took Judge Wilkins to be asking, if there is a federal labor law violation, are employers really in that catch-22? I'm sorry if I misunderstood that question, but and my answer would be, if there is this conflict, and even if there is just some reluctance because of the risk of a federal labor law violation that stops an employer from taking action that it should take to correct an existing case of misconduct in the workplace, then that would be the sort of conflict that concerns me, and I think that the court should protect. Do that, I'm over my time and would like to sort of save some time for rebuttal, if I may.
All right, thank you. Mr. Heller?
Good morning. May it please the court. Joel Heller for the National Labor Relations Board. The court remanded this case to the board with instructions to address the interaction between the NLRA and anti-discrimination law. The board did that, applying its intervening General Motors decision and holding that the familiar right line test should apply to these types of cases. The issue before the court now is the application of that test to the facts of this case. Employer motive is a question of fact, which is reviewed for substantial evidence.
Substantial evidence has to be such as would convince a reasonable person. Is that correct?
A substantial evidence, yes. Could any reasonable fact...
What is your evidence here should be convincing us that they would not have disciplined him for his egregious conduct, but for his protected conduct?
Sure, they would not. The evidence is the disparate treatment evidence, which the board lays out in the case. Sorry, Your Honor?
Repeat, please.
The disparate treatment evidence.
The disparate treatment
Yes.
presupposes a similarity of the persons being treated, is it not?
Yes, it's a similarity. Now, it doesn't have to be identical, but yes, similarity. And similarity is a question of fact.
There have to be a dissimilar protected activity history and a similar violation for it to be fully relevant, wouldn't it?
It would have to be similar conduct in the past that the employer...
What's your closest case, closest evidence of disparate treatment?
That other employees, and not just employees, but also supervisors, were using the very same phrase that Mr. Williams...
Did any of them write it on the sign-up board where their fellow workers would have to be putting their names to participate in the overtime program?
No, we don't have evidence of anyone else writing.
They did not, did they? Did the company have the same kind of strong evidence, e.g. the video, with any of these others that they had with him?
Well, it's not contested that other people were using the same language, including supervisors. Now, I agree, no one else was writing it down.
The time at which they knew about it is not established by your evidence, is it?
The employer knew about it. Yes, there's testimony from employees that they use this phrase in front of supervisors, including Mr. Harmison, who was one of the individuals that Constellium says was decision maker.
Now, is there evidence as to whether or not these other people had been unionists such that if there were an anti-union animus, it would not have extended to them, or would have extended to them also?
All of these individuals were using the phrase, the employees were using this phrase to protest the employer's new overtime policy.
Mm-hmm.
So they were talking about terms and conditions of employment.
So the only animus, the only act as to which you are claiming the protection of the act is the use of the word. Is that correct? He didn't have any prior history of activism?
The record shows, right, the only protected activity we're talking about is his writing.
So I'm wondering if you are claiming this evidence shows animus, why didn't they fire those other people who were engaging in similar activity, but not the same activity?
Well, it is established.
If it were only because of if anti-union animus was a but-for cause, wouldn't they have fired them if they were union activists also?
Well, it is established law, as we cite in the brief, that an employer doesn't have to fire all union supporters just to mean that they unlawfully retaliated against an individual. I mean, I can think of any number of reasons. They could have imagined that.
The record shows that they'd been hit with $1 million verdict for hostile workplace, right?
That's true. In December.
Is it really unreasonable to believe that they fired somebody for an egregious act contributing to a hostile workplace?
Well, the problem with that argument, Your Honor, is that other people were using profane and sexually tinged language.
Is it really, let's look at the yes or no question.
Right?
Is it really unreasonable to suppose that a company that had been hit with $1 million hostile workplace judgment would fire somebody who was egregiously contributing to a hostile workplace?
The abstract, no. But on the facts of this case, the question is whether they would have discharged Mr. Williams absent his protected conduct, not whether they could have.
But the only protected conduct you cited now is the egregious act of putting the language on the sign-up sheet.
Protected conduct
is that protected conduct?
Protected conduct is protesting the overtime policy. I think we all.
The other people protested it and were not fired. He did a more egregious act and he was fired. I don't see what's unreasonable about believing that they were attempting to protect their status as a non-hostile workplace.
So that, I think, goes back to the question of whether the other individuals were similarly situated.
Yes, it does.
Yes, it does. And that's a question of fact, which is reviewed for substantial evidence. Now, the board found that they were similar. And also, I would point out that this court, in its prior holding in this case, found that Constellium disciplined Williams because of the content of his message. Mm-hmm. Not that it was written down or where it was, but the content, the words that he was using. And other employees were using those exact same words, and they were not discharged. That is classic disparate treatment evidence. And the fact that other employees were not targeted for their union activity, again, is not legally dispositive, because an employer could, for instance, think that Mr. Williams was the ringleader.
What would you say is the reason, if there is the disparate treatment you're talking about, what would you say is the real reason for it, non-protectual reason for it, or even protectual? What reason would they fire him if not then, if it's really based on animus?
For example, they could have thought he was the ringleader of the overtime protest movement, and they needed to make an example out of him. They could have decided, well, this is the straw that broke the camel's back. We've been putting up with this overtime protest long enough, but now we're going to go after something.
Yeah, he went farther than the other said, and that was the straw that broke the camel's back. I'm not sure that I see how you have a case on that.
Well, again, Your Honor, I would say that I would point you to this court's previous decision in this case before the remand, where it says they fired him because of the content of his message, which refers to the content of his message, what he wrote, not the fact that the language that he used, not the fact that he wrote it on a bulletin or on the overtime sheet. And so I don't think Constellium can get away from that finding and saying, well, we fired him for writing it down, so therefore he's different than these other individuals. The court has already found
posting it in a public place where his fellow employees were expected to put their names is not different than using it in conversation in your position.
The employees' names, it was a printed list. Everyone's name was already on the list, including Mr. Williams' name. Now, some employees would have to check, like, I will work overtime this day. But I would also point you to evidence that a supervisor on the radio used this very same phrase and told employees, hey, come down and sign the horror board. And so anyone who thereafter went and signed their names, it was as if they were subjecting themselves to the same language. So the fact that he wrote it on this board is not, in that sense, different than what other people were doing. and there was no discipline. I would also point out that other employees continued to use the same phrase after Mr. Williams was fired. That's at JA 107. And there's no evidence that any of them were disciplined. So again, this idea that Constellium was turning over a new leaf is just not factually supported under the facts of this case. And an employer cannot use EEO law to immunize retaliation under the NLRB.
Conversely, are you saying that a union employee can use union status to immunize contributing to a hostile workplace?
No.
So isn't that a wash? That argument washes out, doesn't it?
I acknowledge that there can be a tricky situation, and there can be a rock and a hard place. But here, Constellium put itself in between the rock and the hard place by not taking action against anyone else who is using this language and other profane and sexual.
They may have put themselves on the rock side, but he put them in the hard place, didn't he?
Well, but he was using the same language, and so if they really felt they needed to get rid of this language, they could have done so. They could have done so earlier. They could have even done so. They could have done so in response to Mr. Williams, I would submit. They could have said, everyone uniformly, just like Judge Wilkins was saying, a uniform policy, everyone stop using this phrase. And that would have gotten them some of the way, or perhaps all of the way. It would have gotten them to respond to their fears of hostile work environment in a way that doesn't run afoul of the NLRA. But they didn't do that because we do have two statutes here. It does matter that he was engaged in NLRA protected activity when protesting the overtime policy. I would point to this court's, I think they cite in their, Constellium cites in their brief, language from the court's decision in AdTrans, which was about a broad workplace rule. But I would point the court to page 27 to 28 of that opinion, where it says, we recognize that the uneven or partial application of a rule against abusive and threatening language could constitute an unfair labor practice. And that's the situation we have here. An uneven and partial application of an anti-harassment policy to single out someone engaged in NLRA protected activity. That is retaliation. Disparate treatment is classic evidence of retaliation. That answers the question here in this case. I ask that you enforce the board's opinion unless there are further questions.
All right, thank you. Mr. Kilbert?
May it please the court, Nathan Kilbert on behalf of Local 5668. I'd like to address, first off, the question of the employer who wishes to turn over a new leaf. Contrary to the suggestions of a counsel for appellant, the union is not taking the position that it should be impossible for an employer to turn over a new leaf. Merely that the employer should not be permitted to barely assert that it has turned over a new leaf. I'd like to call the court's attention to the fact that the company announced or reaffirmed its purported zero tolerance policy with respect to harassment in a document dated at the end of February of 2013. But subsequent to that, the company tolerated all of this oral use of the offensive phrase at issue here by both employees and by supervisors. And they did not take action against any of those individuals or against any other individual in the record for harassing or inappropriate conduct until they discharged Mr. Williams some 6 months later in October of 2013. That's not turning over a new leaf. And the board should not be obligated to take an employer's word on that issue.
How does the union reconcile the position it's taking with the fact that there were some union members who felt targeted by this action, who felt harassed, who felt intimidated by this action?
So the company has an obligation to maintain a workplace free of harassment, and we think that they ought to do that. But we think that similarly, they ought not to engage in conduct that retaliates against individuals who engage in protected activity. They ought to genuinely enforce a policy that does not permit harassment. With that,
All right, if there are no more questions, thank you. Mr. Keneally, why don't you take 2 minutes?
Thank you. Just a couple of points in rebuttal. Board counsel referenced this court's 2019 opinion discussing that Constellium took action based on the content of Mr. Williams' message. I think the board counsel is taking that out of context, because the question in that case was about whether the employer was solely motivated by the defacement, or was also motivated by the content. We're not disputing at this stage that both of those motivations were present, and this court even used the phrase "not simply for defacing property." That was the finding that this court made, and I think it's clear on any fair reading of the record that Constellium was motivated in part by where and how Mr. Williams used this phrase. This board counsels mentioned that maybe Mr. Williams was targeted because he was thought to be the ringleader of the protest. There's absolutely no evidence of that in the record. That's entirely speculative, and the record does show that there were 50 employees who filed grievances about the new overtime policy. And so the company had every opportunity, if that had really been its motive, to take action against the boycott supporters. And then finally, just to address the point about whether Constellium turned over a new leaf, board counsel cited JA 107, which is Randy Beagle's testimony. All that says was that he continued to hear the phrase after Mr. Williams' firing. It does not say that Constellium never instructed employees to stop. And I really am at a loss to figure out how an employer who has not corrected misconduct in the past could ever do so when the conduct continues, but is done for the sake of some protected end, because the board general counsel will always be able to point to that past misconduct, even if it should have been corrected, as evidence of disparate treatment. So we would ask that the court deny enforcement of the board's order.
Why couldn't the company say, look, from here on out, whether you are conducting, any kind of sort of protest with respect to this overtime action or in any other context, you can't use these terms. You can't say these sorts of things. And you put everyone on notice that you have a zero tolerance policy, and it doesn't matter whether they are engaging in protected activity or not. And so you have turned over your new leaf, and then the next time that someone does it, you discipline them, even if they're engaged in protected activity. And why isn't the company covered then if that's what happened?
Well, we think that that's what happened here. The company did put out a new rules of conduct, a new anti-harassment policy after the 2012 jury verdict. That maybe it doesn't catch every single person who engages in misconduct. That's not often feasible, especially with things like graffiti.
But the evidence here is that people were saying it over the radio, supervisors are saying it, et cetera, after that new policy has been announced, right? Isn't that the evidence that's in the record?
There's no evidence that any of those people prompted complaints from their coworkers, that led to an investigation, and that the company knew who was engaged in the misconduct and had a meaningful opportunity to discipline them. There's really, I think the evidence is exactly what Your Honor said, but there's not that missing link that shows that the employer knew about it, could have stopped it, and that its failure to do more suggests that it had animus against the overtime protest. Thank you.
All right, thank you, counsel. Madam Clerk, would you call the next case, please?
Case number 21-1208, Abd Al-Rahim Hussein Al-Nashiri, petitioner. Mr. Parody for the petitioner, Mr. Fulmer for the respondent, United States.
Mr. Parody, good morning. Please proceed.
Thank you, Your Honor. Good morning, Judge Henderson, Judge Wilkins, Sentelle, and may it please the court. It is clear and it is undisputed that torture and the use of evidence obtained by torture, except for the purpose of proving torture, is categorically forbidden by Congress. We therefore ask this court to enter a writ of mandamus because otherwise, evidence obtained by torture will continue to irreparably.
Well, counsel, the merits don't seem to have much to do with this case. You've filed plenty of things talking about here. Torture. That you have a great jurisdictional problem, do you not? At least 3, maybe 4 jurisdictional problems. First place, there is a case that says we have, there's one case says we have jurisdiction to issue a mandamus to the terrorism court, whatever it's called, the military review court. But that was whereas in aid of our jurisdiction. So I'm not sure that really gets you there, but assuming you have otherwise jurisdiction here, there's, as far as what's happened in the prior hearing, it's moot, isn't it?
No, Your Honor. And if I can address your questions in turn, this court has jurisdiction in order to protect the record on this case. And I think this case, like in Ray Papa Andrew, in Ray Clinton just a couple of years ago, when you're dealing with even evidentiary issues, but that will get to the integrity of the record that is ultimately available.
Well, assume we have mandamus jurisdiction in the first place. You still have to get around mootness, standing, and rightness. And you don't seem to get by any of them, do you? Whatever happened in that prior hearing is moot, is it not?
It's not, Your Honor. And if I can point to a few reasons why it's not moot, at least under this court's precedence. The first is that respondent has disclosed that there is a vast ex parte record, about 100,000 pages that sit like an iceberg under this case, in which military.
And as long as they're sitting by an iceberg, they're not, they don't give you standing then, do they?
Well, they do because
They do? There has to be a harm that is imminent, actual or imminent, and everything in the record says that it's not. That's not the case.
Respectfully, I would disagree about the state of the record, Your Honor, because they concede that that record is riven with military commission prosecutors and military commission judges using evidence obtained by torture. We have no remedy against that record. But more importantly, the respondents also concede that there are orders by the military commission that remain in effect, which they procured using evidence obtained by torture. And
are those orders before us? You're asking for a mandamus about the use of the evidence.
Yes, Your Honor. So
that is yet to come.
Oh, sorry.
I don't understand what you're talking about the record being out there against us in prior orders. I'm not sure that's even before us.
It is, Your Honor, because we sought a petition. In our petition, the relief we sought was essentially mandatory relief, preventing the government from using evidence obtained by torture, preventing the military commission judge from allowing the government, in essence, to use evidence obtained by torture unless authorized by statute, and to vacate any order.
You didn't get it, but there's not an order harming you from which you can appeal because the order does not say that it can be used. You're trying to say that it can't be used. Okay, so for right now, it's not being used. That prayer is moot. What is the present harm under standing analysis that is being caused by the respondent that can be remedied in this action?
Sure. I would say this case actually looks a lot like True the Vote, which the court decided a few years ago, in which the government has come forward and said it has largely seceded using evidence obtained by torture, but there's still orders of the military commission, not just the record in this case being tainted. Their use of evidence obtained by torture.
Personal to your defendant that is
denying our defendant discovery based on evidence obtained by torture. The government concedes that in their opposition. They simply say, well, that's a small matter. That shouldn't swallow the rule, but certainly for any justiciability purpose.
But the more fundamental problem that I see with your mandamus petition is if there's a conviction, why can't all of that be reviewed after the conviction?
I would say for two principal reasons, Your Honor. One is quite practical, but other I think is quite important. The quite practical reason is the vastness of this record, this ex parte record that we have no ability to seek to have reconsidered. We're actually barred by Section 949P-4 from even seeking reconsideration of the orders that are the product of that ex parte record. That ex parte record is about 100,000 pages pursuant to respondents' stipulation, and we have no ability to review that record. And in fact, that record is actually incomplete because, as we noted in our petition, as they don't oppose, and as in fact this court even noted itself in the Altamir case, not all of these ex parte proceedings dealing with typically evidence obtained by torture, to be perfectly candid, but not all of these ex parte proceedings are even memorialized in the record. A number of them are done both ex parte and off the record, either with the military commission judge or the military commission judge's staff. So this court, in the absence of mandatory relief now, to scrub the taints of torture from this record, this court will essentially get a 100,000-page ex parte record at least, spanning over a decade, during which neither military commission prosecutors nor military commission judges thought there was anything wrong with using evidence obtained by torture. And it will fall to this court's chambers to determine whether or not evidence was used by torture, and it won't even be able to do that fully because of the amount, not only because of the amount of evidence that they'll be reviewing, but because of the proceedings that are not even memorialized.
You're answering this question by saying that the harm is that the record will be tainted with evidence procured by torture and that should be scrubbed. But what particular injury does that confer upon your client?
I would say one, a very practical injury in the fact that in the sense that these orders, certainly the orders that are still in place, all involve withholding discovery. So I think that.
But you haven't brought an appeal from those orders. We're not reviewing those orders. You're asking for a mandamus. Not sure what the existence of those orders, how that helps you. And even your cause of trying to get a mandamus for what's going on now.
Well, because the mandamus we sought was to vacate any orders that were obtained using evidence obtained by torture. And the government has come, and we're shadowboxing a bit here because we have no access to this 100,000-page record. And to the government's credit, they came forward and said, we found at least two that are unquestionably tainted by torture. And that's how they got the orders. And
how do we even know whether those had anything to do with your client?
Because they were in the order entered in this case.
In this case.
They were entered in this case to deny.
Did you appeal from those orders?
I'm sorry?
Did you appeal from those orders?
Well, we only even learned about them. And indeed, we could only learn about anything that goes on in the ex parte process because of respondents' stipulation in their opposition brief that these orders, in fact, existed. And so, that asking us to prove what's in the ex parte record is, we're blind there, Your Honor. By law, we are blind there. And it's the government that's created this record. But if I could get to the second part of my response to your question, Judge Wilkins, I think the important reason is that, torture is different. Torture is poison to the justice system. The Supreme Court has held that for over a century. And to allow the use of evidence obtained by torture to poison the record in a capital case, I think not only calls into question the public integrity of these proceedings, but it makes these proceedings an aberration.
Torture may be different, but attempts to exclude evidence are not rare at all. Or we're going to be creating a precedent that everybody who wants a motion in limine to keep out a confession or a coerced statement or some other sort of evidence is going to be able to come in here and ask for a mandamus instead of going through the trial process and taking the appeal that it's provided for?
Certainly not, because I think torture is different. And in this one respect, and I would say...
Do you have any authority that says that the procedure for suppressing evidence because of torture is any different than for any other motion in limine?
I would say the most analogous case, it's only an analogy because, thank God, torture is not an issue that comes up too often in American judicial proceedings, but the closest...
Coerced confessions come up from time to time.
They do, but but rarely do those.
How is that legally different? I mean,
So
I understand that there's a line between torture and coerced confessions, but not always, sometimes crossed, I think, but I'm not sure what the legal difference is. Test one by mandamus, you should be able to test the other, shouldn't you?
If I can answer your Honor's question just in turn, in respect to precedent, In re Papa Andrew is this court's case saying that when essentially international law questions are implicated by judicial proceedings, that there is a special need for mandamus, even where, for example, an assertion of immunity, as was the issue in that case, would not ordinarily be an appropriate subject for mandamus. And Congress's enactment of Section 948RA is taken almost in hoc verba from the Convention Against Torture. Article 15 of the Convention Against Torture categorically forbids the use of evidence obtained by torture in any proceeding. And so by not granting mandamus, essentially this court is being put in the position of allowing the United States judicial system to become a party not only to a violation of international law, a jus cogens violation of international law, one of the most serious international law rules that we have, prohibition against torture. But if I could also just separate perhaps maybe some of your concerns on the practical, as a practical matter. The difference between sort of torture and coercion, this case, I think, is an example of that. The statements that initially gave rise to this litigation were taken, and without getting into any classified matters, because there's no concession, when a naked man was being hung by his hands and hooded with a power drill to his head. And I strained to find anything like that in the U.S. reporters. And if you're concerned about opening the floodgates, I think there are procedures in place, because a prohibition on the use of torture is a prohibition on the use of torture. And here the government does not dispute that the prohibition on the use of evidence obtained by torture was violent.
But mandamus is ordinarily not used to grant declaratory, right? Isn't it black letter law that you don't use mandamus for that? Because you bring a declaratory judgment action? You want declaratory relief?
And we're not asking for declaratory relief. We're asking to have the orders that the government itself concedes, and other orders as well, that were obtained using evidence obtained by torture, to be vacated. That's an entirely backward-looking, non-forward-looking remedy. And if you're concerned about the flood rates, I think that really is the threshold. We have to show that our entitlement to relief is clear and indisputable. Any mandamus petitioner does. There's a dispute about coercion. I imagine in most of those cases, they will not have a clear and indisputable right to relief. Here we have a clear and undisputed right to relief, because the government not only concedes that we were correct in objecting to the evidence when they first attempted to introduce it, but that they should not have used it, and that practice that they had been engaged in for 10 years has essentially made the record in this case potentially riven with evidence obtained by torture. I do see that I've cut into my rebuttal time.
I mean, why isn't a better practice here for you to ask the trial court to identify all of the orders that were, I guess, issued against your client's position, so either denying you discovery or allowing the admission of evidence or denying you some sort of relief, to identify every single one of those orders where evidence of torture was admitted in the procurement of those orders, and then ask them for a ruling as to all of those orders, that all of those orders should be reconsidered and or withdrawn. And then if you don't like what you get at that point, then you come back to us, because then we know what we're dealing with, and we have a case or controversy where we can order some specific relief. You're asking us, you're saying that you're shadow boxing. Well, we're shadow boxing too then. But you could take some action, it seems, so that we're not shadow boxing.
To be fully clear, Your Honor, we did ask for that in the CMCR, and the CMCR said that was not ripe. But if I could point to just two other obstacles that we would confront in getting that relief in the first instance before the Military Commission. The first is the Military Commission judge in this case has ruled on the merits on this issue. And even though that decision was sort of vacated in a reverse Munsingware, that under this court's precedence, Action Alliance being the most obvious, that's still a precedential opinion that has not been countermanded by any court. So that is the law of this case. And second, as I mentioned briefly before, under Section 949P-4, we're actually precluded from seeking reconsideration of any order dealing with classified discovery. So we would essentially be asking for an inquiry into something that we would be in essence relying on the good graces of either the military commission or the government to sua sponte attempt to remediate. And again, we're not asking.
Nonetheless, as far as doing anything about the use of this evidence improperly that we can do something about, why isn't the procedural path to go to trial, and if it's used against you, then appeal? If it's not used against you, then the question remains moot like it is now.
That's not correct, Your Honor, because the statute, and frankly international law, but more importantly, I think the statute forbids the use of evidence obtained by torture at any stage of the military commission litigation.
Right.
And we already have discovery orders that are still in effect that have withheld exculpatory potentially evidence, the names of witnesses, in fact, from us.
I don't know that the international law has anything to do with discovery. What we can grant relief on, it would be the improper use of it.
That's correct.
If it is used at trial, then you get to appeal it.
But the statute,
if it's not used, then you don't have a case.
But the statute sweeps broader than that, and that's ultimately what brought this case here, Your Honor, is that the statute forbids not simply the use at trial, but the use in any stage of the proceeding. And they have used it at various stages of the proceeding. They have orders that—
And those have been done and they're moved.
That's not correct, Your Honor. Those orders remain in effect. Those orders were not— those orders literally today remain in effect. So we are in the same exact position we were when we first filed this petition in this court. Indeed, when we first even objected to the decision of the military commission when it ruled that it could use evidence obtained by torture for any purpose other than trial. And that's the problem here, is the government essentially has used this evidence. They've built a massive record using evidence obtained by torture to shape the discovery that we have available to us in a capital case. And
I guess here's where I guess there's a disconnect here. If you have requested exculpatory evidence or a name of a witness, something where you were saying, give me something, and it wasn't given to you. And part of the reason it wasn't given to you was because of some evidence of torture that was admitted in an ex parte proceeding. And that formed part of the reason of why that wasn't given to you. If there is a conviction, you can raise as one ground of error that there was something that we wanted given to us that wasn't given to us, right?
So we can, but again, I think the limitations, and I don't want to repeat myself, but I think the limitations of that is it does not remove the taint of torture from the record in this case. Everyone is going to frankly know that torture has tainted this case, that these are the torture tribunals. But I think more importantly, the only reason we even know about those two orders is because my friend, again, to their credit, disclosed them in their opposition brief. And, again, just like True the Vote, you can't be— mootness is an offer-on factor. You can't be a little bit pregnant and you can't be a little bit moot. The case is either— they've either ceased, the case is moot, or it's not. And it's at least not moot because those two orders are still in place. And we only know about those orders because they disclose them. The existence of other orders is either going to be left— how do we remedy that? We actually don't have a way, because of the ex parte character of those proceedings, to remedy that ourselves, which means the only solution to that will be this court reviewing that record ex parte through its chambers and attempting to divine potentially how these rulings might have affected the case. And to the extent mandamus, again, is about protecting this court's jurisdiction, the easiest way, the most practical way, and I don't think it would be a heavy burden, frankly, for the government to meet, would be to simply vacate the ex parte record and allow the government to resubmit motions clean of evidence obtained by torture, to ensure that when the record does come up to this court, it's not trying to parse when potentially torture may have implicated it. And for the reasons— I know I'm over my time, but if I could just say one more point. For the reasons I identified in our 28-J letter from about a month and a half ago, it's not always going to be obvious when evidence obtained by torture, not even evidence obtained by torture involving this case, is being used. That's a fairly subtle process. And we do think that should be done in the first instance in the military commission. And the only way that will be done is if this court vacates the ex parte record, which will give an impetus both to respondent and to the military commission judge to proceed and clean up the record on this case under a correct view of the law, under what, frankly, respondents now concede is a correct view of the law. So I do see, Your Honor, that I have gone over my time.
All right, thank you. We'll give you a couple of minutes in reply. Mr. Palmer?
Thank you, Your Honor.
Good morning, may it please the court. I'm Joseph Palmer from the Justice Department. Our primary submission is that the petition for mandamus is not ripe. The government withdrew the statements that gave rise to this litigation. The CMCR vacated the order that held that they were inadmissible. And the government now agrees that Section 948RA applies at all stages of a military commission case. And the government also acknowledges that to the extent that there are pre-existing orders in the ex parte record that are predicated on statements obtained through torture, that those orders should be vacated and reconsidered without the statements. But as the CMCR noted, the military trial judge has not yet been asked to conduct a process to determine whether there are any such orders exist. And
well, your friend on the other side says that the rules preclude them from making such an ask.
I don't think the rules preclude the petitioner from moving the military commission to identify whether any such orders exist, particularly in the context where the government agrees that if there are such orders, they should be reconsidered. And so the reconsideration could take place once they're identified on the motion of the military commission.
So let's suppose we deny the mandamus petition on the grounds that we're kind of holding you to the representation that you're making, that's the position that you're going to take, and it gets remanded, and for whatever reason, at the military commission, the judge refuses to grant that relief and refuses to reopen the record or scrub the record, so to speak. Do we have mandamus jurisdiction then if he brings another petition?
I think in that circumstance, well, first, I think that he would be required to go back to the CMCR because essentially the CMCR said that the case was not right because that process had not yet occurred. And then the CMCR said that if that process did occur, that would cure the ripeness problem. We still think there is a mandamus jurisdiction problem because the mandamus standard requires that the issue not be capable of being reviewed on appeal from final judgment. And we think that this issue of admissibility of evidence is capable of being reviewed in that circumstance. But we do agree, we don't dispute that.
How can it be reviewed if petitioner's counsel isn't privy to it?
Well, a review of ex parte records routinely takes place in Article 3 courts, for example, under the Classified Information Procedures Act. That act and the Military Commissions Act has provisions that closely parallel CIPA. And that act requires that the ex parte submission be recorded in the record, made available for the post-judgment review by the appellate court. And so this court's review could take place the same way as it does in national security prosecutions in Article 3 court, reviewing district court determinations under CIPA the same way as occur in this case.
I understand the CIPA process, but it's very easy to kind of identify what we are reviewing because all of the information that we're reviewing is classified. And so the question is, should it have been turned over? Should it have been redacted? Or was there an adequate substitute that was provided, et cetera, et cetera? Here, the review would be quite different, wouldn't it? We would get hundreds of thousands of pages and then without any guidance from the petitioner, have to on our own go through and see if there is any evidence that was admitted do the torture, and we're supposed to pick through that and figure that out and remedy that if that occurred?
Well, we don't dispute that the military commission judge who issued those orders should do that review in the first instance, and that the government itself has begun conducting that review also, and we have every incentive to correct any errors that may exist in the existing ex parte record. And that following that process, of course, there would be review by the CMCR, which has full de novo fact-finding review power. And in that circumstance, then there would have already been a final judgment and review by the CMCR to refine the issues that might remain for this court's review. And in terms of the difficulty, again, from our perspective, the military commission judge is the one in the best position to conduct that review in the first instance, and then the court would have before it that court's process and determination of how it made the judgment that the record was free from errors under Section 948RA.
That kind of gets us back to where we began, which is what if the military commission judge declines to undertake that review or to entertain a motion from petitioner on remand? You're saying, well, then they would appeal that to the CMCR. And then let's suppose the CMCR doesn't take any action or affirms. Do we have mandamus jurisdiction at that point?
Well, I think that would cure the ripeness issue, that case would be ripe. I think we would still take the position that because it's an issue of admissibility of evidence, that it could be reviewed on any appeal after final judgment. But I don't think that there's a likelihood that the military commission judge would do that, because in the context of the statements that gave rise to this litigation, the military judge did agree to the government's request to withdraw the statements and did reconsider that order without relying on the statement. And I don't think there's any reason to doubt, especially where the government agrees that that review should occur, the military commission judge should be given the opportunity to conduct that review in the first instance. If I could say one thing briefly about the two orders that we've already identified through our own process. The government has also moved to have those orders reconsidered as well. And so as the record now stands, there are no orders of which the government is aware that contain Section 948RA errors that the government hasn't sought to reconsider. And we acknowledge that to the extent that the military judge's process discloses that there are any further such orders, that they should be reconsidered without such statements.
So you're making the representation that that is the position of the government and that those are the actions that the government is going to undertake.
Yes, the government has already begun a review process as we described. And the government has every incentive to make sure that to do its best to make sure that the record doesn't contain within it Section 948RA errors. And we also don't dispute that the military commission judge should be given the opportunity to do that review itself. And as the CMCR noted, the military judge hasn't yet been asked to do that review, but we acknowledge that review would be appropriate.
So you're answering my questions very carefully, which I would expect that you would, but you're answering, I asked the question the way that I did for a purpose, because you are asking us to rule in a certain way based on representations. My view of that is that if I'm going to take you up on that, and you should be stopped from acting contrary to the representations that you make to this court that caused us to grant you the relief, or to decline to grant petitioner the relief. You said the government has every incentive to take certain action, but you didn't say that the government is going to take that action, and that you are representing to the court that that is the course that the government is going to undertake. You understand my question?
I think so, except that I'm not completely sure of what is the action that the court is asking me to confirm that the government will take.
Well, I've asked a series of questions about, if this isn't right, then how will it become right? And how can petitioner get relief before the military commission with respect to reconsideration and/or the vacature of orders? And I heard your last response as saying, well, we have every incentive to make sure that that happens. What I'm trying to understand is, are you making a representation that you are going to move for that to happen and not oppose a motion that is made by petitioner below for that to happen? Because if you're not prepared to make that representation, then we need to know that now.
Thank you, Your Honor. So we do not dispute and will not oppose a review by the military commission judge to conduct a review to identify whether any ex parte orders exist that contain Section 948RA errors. We agree that that process should take place in the military commission.
Thank you. What about the issue that was the subject of the most recent 28J letter with respect to the admissibility of evidence that may or may not have been procured as a result of torture that comes from a third-party witness? Does that affect the ripeness or mootness here?
I can't speak specifically to the statements that were made earlier this week. I just haven't had the chance to specifically review that transcript. But what I can say that the government's position with respect to Section 948RA is that statements obtained through torture of anyone, whether it is the defendant or a third party, are inadmissible under Section 948RA at any stage of the proceedings. And with my understanding, and again, this is just based on a sort of secondhand report, is that the issue being discussed in the military commission has to do with derivative evidence, not statements that were directly obtained from a third party. And on that issue, I think the government hasn't yet established a position. But with respect to whether the government doesn't maintain that under Section 948RA, statements of third parties are admissible, I don't think that issue is raised in the petition that's before you now. The statements that gave rise to this litigation were statements of the petitioner, and the parties haven't briefed the issue of statements of third parties or issues of derivative evidence. And I would urge the court to allow us to file a response to the 28J letter to clarify what was said earlier this week.
Thank you.
Well, Mr. Palmer, in your brief at 25, you're pretty categorical. You say, and I quote, "The government has now concluded that Section 948RA prohibits the admission of statements obtained through torture or cruel, inhuman, or degrading treatment at all phases of a military commission. Are we now supposed to take that categorical statement and read into it, so long as the torture or cruel, inhuman, or degrading treatment concerned only the detainee who's on trial?
No, Your Honor. The government's position is that the statute, under the statute bars admission of statements obtained through torture of any person, whether it was the defendant or a third party. Either way, the statements
All
are.
right, so what about this 28J letter that says the prosecution indicated that it was the position of the United States that 948RA only prohibited the use of evidence obtained by torture against the accused, not third parties? How was that indicated? I mean, this is a pretty serious change in position if it's true.
Your Honor, what I can say before you now is that that's not the government's position. The government's position is that statements obtained through torture of third parties are inadmissible, and that I understand the issue that was discussed in the military commission to relate to derivative evidence, not statements obtained that were directly obtained. But I just ask the court's indulgence to give us a chance to
All right.
respond
I don't know
to
what
the
you mean by
28J once
derivative, but I at least want you to respond to this 28J letter.
Yes, the government will do so, Your Honor.
All right.
There are no further questions. Thank you.
All right, Mr. Paredes, why don't you take a couple minutes?
Thank you, Judge Henderson. Just respecting the 28J, I was informed by Captain Miser that we received the top secret transcript of proceedings last evening, and we can provide that to this court under seal in case there's any ambiguity. At least as we understood it, and certainly based on the reporting from the New York Times, the position of the military commission prosecutor was that, yes, it began as a dispute about derivative evidence, but the argument was essentially made as the alternative argument that evidence obtained by torture of third parties was not subject to 948R, I believe, on a standing challenge, if I understand the framing of the argument correctly. But we'll provide the transcript to this court, so there's no question. I want to actually touch on the main point, I think, of agreement between the parties. I 100% agree that the military judge is in the best position to do this kind of audit. Certainly not this chamber's, a decade from now when this case is on post-trial appeal. Judge Sentelle, I think I was before you in this case about 8 years ago, and we anticipated that this case would probably be on appeal now, and that has not turned out to be true. But I think the most important reason why the writ is necessary is, well, actually two reasons, if you might let me. One is these kinds of discrepancies. There's been a lot of shifting around of positions, a lot of difficulty in ascertaining what the government's position is. And so if there was ever a situation where just a clear statement from this court was going to be necessary and beneficial to improving and correcting the record, it is this case where we have these kinds of...
What we have before us is the case, the capital case in which the harm that can come out of this is an error at the trial that could result in a terrible verdict. I'm not sure why it still isn't an adequate remedy for anything the government does wrong. This notion that there are orders out there in the ether, that we should do something about taking the orders out of the ether is, it seems to me a very strange and new theory that he is somehow harmed by the very existence of the orders then we can cure that harm by the long process you talked about, rather than simply letting the case go to trial and see whether there is an attempt or an actual use of improperly obtained evidence, and if there is by that error some verdict reached as to which you can appeal. I'm not sure why we need an extraordinary equitable remedy to solve what at its root is theoretical declaratory relief, as Judge Wilkins said, that these orders were obtained improperly in the past, and it would be improper to use them. Yeah, okay, fine. That's the law. We're not doing anything new. You yourself advanced that they can't be used legally. So why isn't it the norm that we would let this just go back for trial, and if there's error, then we hear it on appeal?
Well, again, there are orders that remain in effect. And
so what? There's all kinds of orders that get made
that
never do result in any prejudice at a trial and never have to be reviewed. That happens in all kinds of cases. I understand the stress of being a representative in a capital case, but as far as the law involved, I don't see why this is any different than any other case, certainly than any other capital case, that if the orders are just out there, you're asking for declaratory relief, not correction of an error.
We are asking for vacatur, and so we're not just asking for declaratory relief. If I can just...
yeah, you're asking for a vacatur of something that right now isn't doing anything to you.
That's not correct. It's withholding...
If it does something to you, then you get to appeal.
It's withholding evidence from us.
Beg your pardon?
It's withholding evidence. The two orders, at least that they've disclosed, are still in effect. Or evidence to withhold evidence, including the names of witnesses who were implicated in the torture of my client. So that's doing something to us. And that's affecting how we can even have this trial, whether it will be a fair trial. And we're not up here because we're litigious. We're up here because this case has been going on for nearly 15 years. And our client believes he might be acquitted if he has a fair trial. But this is not a fair trial. The evidence is tainted by torture. And so if I can just briefly correct a few things my friend said. Is the military commission prosecutors did not move to reconsider these orders or any orders. They moved to withdraw their pleadings. If you look at the order the military judge actually issued respecting this that we submitted on Friday, he even notes that the rulings remain in effect. And essentially, they're simply redacting. I don't quite know what that means, but they're changing, whitewashing order motions that they submitted whilst leaving the orders in effect. And I think most important, is the fact that the military commission judge disagrees with the government's new position. He disagrees with our position. And while we welcome their change of position, we welcome the representations that they won't oppose our requesting relief, there's no reason the military commission judge can or should grant that relief, because unless the position of the government is that the military commission judges are simply there to adopt whatever argument the government has adopted at this particular point in time, military commission judge issued a merits ruling. It's lengthy, it's reasoned. It remains the law of this case. And in the absence of an order from this court, it will remain law of this case. And so I understand this court's concerns, but I think the relief we've asked for is incredibly practical to implement. It's the easiest way to ensure the protection of the record on appeal. And it's the only way that this court can ensure that the justice system doesn't become a party to torture. I don't think I ever thought I would have to say that from the podium of an American courtroom, but that's what's at issue.
So as a prudential matter, government seems to be taking a stronger position now, at least, that it believes that those orders should be vacated and reconsidered. At least I believe that that's what I heard your friend on the other side say. As a prudential matter, why shouldn't we see how that plays out? Because that's the question. Why shouldn't we wait to see how that plays out? And if it doesn't play out and you don't get relief, and the CMCR doesn't grant relief, you can come back then.
Two reasons, if I might, Your Honor. The first is this case has already been going on for 15 years, and this government has been given a lot of time to see how things will play out. And asking, we may not be back here, if at all, in a number of years on this same issue. And I think, like judicial misconduct, which was the issue that previously tainted this case, I think torture is just as serious and just as damaging to the public reputation of the proceedings, and there's a need for the court to stamp it out as quickly and decisively and clearly as possible. So prudentially, I would say that those concerns should outweigh.
All right, if there are no more questions, Madam Clerk, if you give us an adjournment.
Thank you, Your Honor.
Thank you.